So hello, everyone. Thank you for joining us for this discussion on U.S. support for atrocity accountability through the International Criminal Court. As a few housekeeping matters, our thanks to the Criminal Justice Section at the American Bar Association and the Center for Human Rights for support of the projects that organized the event today and this webinar. This is a non-CLE program, and just a reminder that it is being recorded, and we'll post the recording later online as well. And we'll be saving a few minutes at the end for questions, so please feel free to our listeners to use the Q&A function, not the chat, the Q&A function, to ask questions of the panelists, which I can field later on, and I'll give you a reminder as well. So we're going to start with welcome remarks from Michael Greco, and then I am going to do a short presentation outlining the domestic U.S. laws at issue that we're going to talk about today so that we're all on the same page, and then we'll turn it over to our panelists for a discussion. So to start, Michael S. Greco is a former president of the American Bar Association in 2005 to 2006, a former chair of the ABA Center for Human Rights, and within which he continues to chair a public health legal services research project and the Atrocity Crimes Initiative and its International Criminal Court project, which organized today's program. Mr. Greco was a retired partner in the Boston office of the global law firm K&L Gates, LLP, where he has been a trial lawyer, arbiter, and mediator, highly recognized for his work protecting legal aid to indigents in the United States and protecting human rights and the rule of law domestically and internationally. And since 2012, he's also been a visiting professor of the practice of law at Peking University School of Transnational Law in China, where he teaches international criminal justice. So Michael, over to you for an introduction.
Thank you very much, Kristen. Well, good afternoon, everyone, and welcome, and thank you for joining us today. What I want to do is spend 4 minutes to give some background about what the American Bar Association and the International Criminal Court Project and the Atrocity Crimes Initiative that Kristen and I are both involved in very, very deeply. The Atrocity Crimes Initiative of the ABA is a group of projects that focus on atrocity crimes prevention, response, and accountability. And as Kristen mentioned, the ABA Criminal Justice Section and the ABA Center for Human Rights jointly support the efforts of the Atrocity Crimes Initiative. I will comment briefly on several ABA policies, among many, that are relevant to today's program, and on the work of the Icc Project during the past 11 years of its existence. The ABA has a long history of supporting international criminal justice institutions and of encouraging U.S. involvement in international criminal justice efforts. In 1978, the ABA urged the establishment of a permanent international tribunal with jurisdiction over atrocity crimes. The ABA participated as an observer at the 1998 Rome Conference, at which the ICC was created. And in 2001, the ABA recommended, through policy adopted by the House of Delegates of the ABA, that the U.S. should accede to the jurisdiction of the Rome Statute and the ICC. Since then, the ABA has adopted a series of policies supportive of the ICC, including in 2010, a policy, quote, urging the United States government to expand and broaden United States interaction with the International Criminal Court, including cooperation with the court's investigations and proceedings, close quote. In 2020, after the ICC's prosecutor and personnel were threatened, endangered, and sanctioned by the Trump administration, the ABA urged all, quote, governments to observe, respect, and protect, close quote, the ICC's independence, a point on which ABA presidential statements were immediately issued. ABA policies also have addressed the United States domestic, legislative, and institutional framework on atrocity crimes, including in 2014, quote, a policy, quote, urging Congress to enact legislation to prevent and punish crimes against humanity, close quote. And in 2017, urging Congress and the State Department to ensure that the function of supporting criminal accountability for mass atrocities should continue to be located in the State Department Office of Global Criminal Justice with sufficient resources and experienced leadership. These and other related ABA policies and presidential statements are available on the ABA website and on the Icc Project's educational website. The Icc Project was created in 2011 to implement the ABA's policies on international criminal justice, to serve as a source of accurate information for the American legal profession and the public about the Icc, and to support and strengthen the Icc and a better U.S.-ICC relationship through education, advocacy, and engagement with the court that the project has steadfastly stayed with. We are fortunate to have 3 members of the Icc Project's Board of Advisors here today who have substantial experience regarding global atrocity crimes, prevention, and accountability. I now turn to moderator Kristen Smith, who is the director of the Icc Project and of the Atrocity Crimes Initiative, to introduce our panelists and begin the discussion.
Thank you. Our first panelist is Ambassador David Sheffer. Ambassador Sheffer is a senior fellow at the Council on Foreign Relations, where he focuses on international law and international criminal justice. He's also a clinical professor emeritus and director emeritus of the Center for International Human Rights at Northwestern Pritzker School of Law in Chicago, and holds affiliations at other universities as well, such as KU Leuven in Belgium and Arizona State University, as well as being vice president of the American Society of International Law. And particularly relevant to our discussion today, Ambassador Sheffer was the first U.S. ambassador at large for war crimes issues and led the U.S. delegation to the UN talks establishing the International Criminal Court, and actually signed the Rome Statute on the United States' behalf in 2000. He also negotiated the creation of 5 war crimes tribunals, and from 2012 to 2018 was the UN Secretary General's special expert on UN assistance to the Khmer Rouge trials. Our second panelist is Professor Jane Stromsa. Dr. Stromsa is the Francis Cable Brown Professor of International Law at Georgetown University, where she specializes in justice and accountability for international atrocity crimes and international human rights. Dr. Stromsa served in government as deputy to the ambassador at large for global criminal justice at the U.S. Department of State from 2013 to 2015. She also served as a senior advisor on rule of law and international humanitarian policy at the U.S. Department of Defense and at the National Security Council as Director for Multilateral Affairs. She received her doctorate in international relations from Oxford University, where she was a Rhodes Scholar, and her law degree from Yale. And our third panelist is Ambassador Clint Williamson. Ambassador Williamson is the Senior Fellow for International Rule of Law, Governance, and Security at the McCain Institute for International Leadership at Arizona State University, and a professor of practice at the Sandra Day O'Connor Law School at Arizona State University. He served as ambassador at large for war crimes issues from 2006 to 2009. And prior to this appointment, he served as Senior Director for Relief, Stabilization, and Development, and as Director for Stability Operations at the National Security Council, as well as in other roles within the United Nations and the European Union, including as Chief Prosecutor of the EU Special Investigative Task Force in Brussels from 2011 to 2014. He previously also served as Director of the Department of Justice in the UN mission in Kosovo, and as a trial attorney at the International Criminal Tribunal for Yugoslavia. So I think you'll all agree they're the ones to have in this program, and we're very grateful for their time today. Before we turn it over to a discussion, as I said, I'm just going to take the moderator's privilege to give a short introduction to the topic and then the actual legal framework that's going to color a lot of our discussion today. So As you all know, the United States has historically played a leadership role in international criminal justice and supporting institutions at different levels, but has a more complicated relationship with the International Criminal Court, as our panelists can shed more light on based on their own experiences. And the legal framework of the United States both reflects concerns about the court at the time of its founding in the early 2000s, but also continues to impact the ability of the United States to engage with the court. And the situation in Ukraine in particular has brought these challenges to the foreground with increased immediacy as the United States government examines what kind of support it can provide to accountability efforts for widely documented atrocities. And I'll note, which I think will be interesting to our participants, that the State Department officials have recently said in speeches at the UN and before Congress that the ICC is included in the constellation of institutions they'll be supporting to achieve accountability. But our conversation today is aimed at illuminating the challenges that remain, what opportunities might still be possible for US support to the ICC and investigations in Ukraine and beyond, and how this discussion impacts US policy on the court more generally. So with that, I'm going to go to a short presentation on the legal framework. Bear with me just a minute. All right. Hopefully we can see that. If not, someone let me know. Okay. So the first piece of legislation that impacts the US relationship with the ICC is the Foreign Relations Authorization Act from fiscal years 2000 and 2001. This was enacted as a part of an Appropriations Act, but it's treated as a permanent restriction. And the operative language is in 22 USC section 7401B. And that says, as you'll see on the screen, that none of the funds authorized to be appropriated by this or any other act may be obligated for use by or for support of the International Criminal Court unless the United States becomes a party to the statute. And then there's been one kind of more modern change that might impact that restriction in recent Consolidated Appropriations Acts for 2000. Oh, I'm sorry, that's a typo. It's for 2020, 2021, and 2022. Apologies for that. And the operative language there is in section 7049B on war crimes tribunals. And you'll see the text on your screen that says that no funds should be made available to the ICC, but provided that funds may be available for certain categories of assistance: technical assistance, training, assistance for victims, protection of witnesses, and law enforcement support related to investigations, apprehensions, prosecutions, and adjudications of genocide, war crimes, and crimes against humanity. So this type of language needs to be reenacted to be effective, but it has been reenacted in that same form for the past 3 years and is in the current Appropriations Act right now. And then the second kind of set of restrictions is the American Servicemembers Protection Act from 2002. That is codified in 22 USC sections 7421 to 7433. Its title and congressional findings suggest its purpose is to protect American service members and officials from risk of ICC prosecution. It is also treated as having permanent effect. And some portions, such as those on military assistance, have since been repealed, but many of the prohibitions remain operative. And it was passed with bipartisan support. That was the one I clicked through a bit quickly. So the first kind of set of big restrictions are in section 7423, which broadly prohibits cooperation with the International Criminal Court, including responding to requests for cooperation, preventing US government agencies from transmitting letters rogatory and other requests for cooperation, preventing extraditing persons from the US to the ICC, another funding restriction on using appropriated funds to assist the investigation, arrest, detention, and et cetera of US citizens. It limits mutual legal assistance obligations. and prohibits investigative activity on US territory. And then kind of the broadest one is a prohibition on providing support to the ICC, which is defined later in the statute as assistance of any kind, including financial support, transfer of property and material support, services, intelligence sharing, law enforcement cooperation, training and detailing and personnel, and in the arrest and detention of individuals. So that, you know, as you can imagine, that could apply to a broad swath of support activities. And these restrictions only apply to the ICC, not ad hoc tribunals, and they don't prohibit communicating US policy. There's a few other restrictions that are just good to know about, but I think aren't the probably crux of the discussion. There's restrictions on US participation in peacekeeping operations with kind of certain ways that that could be overcome, or that the US could participate. And there's also a prohibition on direct or indirect transfer of classified national security information and law enforcement information to the International Criminal Court, both directly, and then it also asked the president to ensure that transfer couldn't happen through a third party as well, such as a state that's a state party to the ICC or the UN. And then there's also this provision, which authorizes the US to use any means necessary to bring about release of US individuals detained at the International Criminal Court, which gave the statute its nickname, the Hague Invasion Act. And then just briefly, we're almost through, there's a few waivers to waive kind of the broad prohibition on cooperation and the information transfer one. And those, yeah, in section 7422, and then they have quite onerous requirements, which you can read more about in the statute if you're interested, but one of them includes a potentially binding agreement with the ICC that there wouldn't be a prosecution of US personnel. There's another kind of potential waiver / exception in 7430 that says that those prohibitions shouldn't apply to specific matters involving the International Criminal Court taken or directed by the president on a case-by-case basis and the exercise of presidential constitutional authority as commander-in-chief or the executive power. To my understanding, these waivers haven't been used, but that's the best of my knowledge. So if you know differently, please feel free to let me know. And then the main exception, which I think is most of our conversation today, is called the Dodd Amendment for the senator that proposed it. And it's in section 7433. And that reads, as you'll see, nothing in this subchapter shall prohibit the United States from rendering assistance to international efforts to bring to justice several named individuals or other foreign nationals accused of genocide, war crimes, and crimes against humanity. So I'll now turn to our panelists. For the first question, with these restrictions in mind, how have they impacted US decisions to engage with the ICC in the past? What kind of support or engagement with the ICC happened during different administrations in which you served? And what, if any, changes occurred over time? And I think we'll start with Ambassador Sheffer.
Thank you so much, Kristen, and thanks, Michael, for those introductory remarks. And of course, I'm very, very privileged to be with my longtime colleagues, Jane and Clint, in this discussion. We've had a long journey with the American Bar Association, which has always been there, I would say, having our back, frankly, on the criticality of the International Criminal Court, whether we're a party to it or not. And so I just want to recognize that. I think what I would just say is I will just speak from my experience in the Clinton administration, and it can be stated fairly simply that this is a court that President Clinton did want to have created. He said it publicly 6 times during his 2 terms in office, and he said it even more, or at least many times after he left office. So he confirmed his point of view many times. And I was under instruction to help make it happen. So I did not have instructions that said, kill the court or don't build this court. Quite the opposite. It was build the court. President Clinton wanted it to be part of his legacy. There's no question about that. And when you have a boss like Madeleine Albright, who was first UN ambassador and then Secretary of State, she too wanted to build the court, get it done. And so those were my walking instructions. And of course, as you get into negotiations, there are issues that pop up. You have to have interagency clearance here in Washington. It's always a laborious process. Treaty making is sausage making here in Washington. And so you do have to have a lot of clearances. And that, of course, was a daily effort on my part in particular to try to get all of those clearances to keep moving ahead with the negotiations. You know, what happened in Rome was that we didn't have exactly the document we wanted, and there were a couple of issues that people dug their heels in back in Washington. And so the final instruction that I got was, you cannot vote to move this final text forward. You have to call for a vote, put people on record, which I argued at the time was a mistake, but I was overruled. And so we sort of entered a rogue gallery, you know, with Libya and some other countries, Iran, et cetera. And that's just unfortunate. But for the next 2 years, 1999 and 2000, we went back to the negotiating table for the rules of procedure and evidence, the elements of crimes, and to look for formulas that would make us feel more comfortable with the court. And we did find some of those formulas, and we put them into those documents. Very, very important, little tiny details, but they accumulated into a very important step for the US government, which was a set of recommendations to the president in December of 2000 to sign the Rome Statute. And you know, it's fairly, I think it's fairly public knowledge. I mean, the recommendations, I recommended signing it. Madeleine Albright, as Secretary of State, recommended it. The Department of Justice, Janet Reno, recommended it. The National Security Advisor, Samuel Berger, recommended it. But then there were some do not sign recommendations, the Defense Department, the Central Intelligence Agency. So that is what the president had in front of him. And on December 31st in the morning, he decided that we would sign within hours of the last opportunity to do so. And I trudged in boots through the snow of New York City to the United Nations. And I had the plenary power to sign the statute, and it was done. But of course, ratifying is a completely different issue. And we had our difficulties with that, even in the few weeks we had left in office, to explain that signing is one thing, and then getting people to support ratification may require other steps. And then, of course, when the Republican administration of George W. Bush came in 2001, then the position of the United States changed. So that's kind of the trajectory. And I think I'll just leave it at that, Kristen.
Okay, great. So Ambassador Sheffer talked about kind of some of the challenges when the statute was negotiated. Ambassador Williamson, how did these legal restrictions play out when you were serving, which I think was during the Bush administration and the first year of the Obama administration? What kind of engagement was there during that time?
Yeah, thanks, Kristen. And first of all, I would just echo David's comments about the amazing role that the ABA has played, and particularly Kristen and Michael in particular, with working with the Office of Global Criminal Justice, with support on these issues with the ICC. It's been critical and long running, and it's been a very strong partnership. So kudos to you guys for the great work you do in this. Yeah, I can pick up the timeline a bit where David left off. I came into office as Ambassador at Large for War Crimes Issues in 2006. So I did serve the last 2.5 years of the Bush administration and the first year of the Obama administration. The intervening years between David's term and my term were really pretty dark days, I think, in terms of the US relationship with the ICC. particularly during the first term of the Bush administration. John Bolton, who at that time was an Undersecretary of State, really led the charge in this anti-ICC policy in the US, which was often couched as being non-cooperation with the court, but really went much further than that. It was really a determined effort to undermine the court as an institution, and maybe even to go so far as to say to destroy it. So this played out in a lot of different ways during the first term of the Bush administration, including the use of what were called Article 98 agreements. And these were agreements that the United States pressured other states into signing, which basically was a commitment that they would never turn over US citizens for prosecution at the ICC, would not cooperate on ICC investigations against the US. And during much of this time, during the first term of the Bush administration, I was serving at the National Security Council, and Condoleezza Rice, who was then the National Security Advisor, really just thought that this whole approach and these Article 98 agreements in particular were self-defeating for the United States. I mean, particularly because the leverage that the US was bringing to bear to get countries to sign these agreements was to cut off military assistance to countries, some of whom had been long-running allies. I was not specifically working on international justice issues at the NSC, but I had recently come back from working at the Yugoslavia Tribunal, and often made this argument to Secretary Rice of, or National Security Advisor Rice at the time, of how ludicrous this was, for example, to have the US ambassador in Belgrade go into the Serbian government and say, you must turn over Ratko Mladic and Radovan Karadzic for trial at the ICTY, and then in the next breath, basically put an Article 98 agreement in front of those same Serbian officials and say, but please sign this saying that you will not turn over any US citizens to the ICC. And she got that. I mean, she understood that this was just ridiculous. And even from a very pragmatic point of view, to have a cutoff of US military assistance to countries tied to this over what was a very unlikely contingency in the first place, but to cut off US military aid, and then inevitably those countries would seek that elsewhere, often with US adversaries. So when she became Secretary of State, one of the first things she did was reverse this policy. And in late 2005, she had asked if I would be willing to come over as ambassador for war crimes issues. And I agreed to do this. And really my marching orders from her were to try to undo the damage that she felt had been done during the first term of the Bush administration. And so we did a lot of different things over the remainder of the Bush administration, which included, first of all, just engagement with the ICC. So I was meeting with the ICC prosecutor, with the ICC president, going regularly to The Hague, exchanging information. We started providing intelligence information to the court. We started helping them with targeting of fugitives, giving information that might lead to the arrests of fugitives. And then I think foremost among the changes was a much more supportive political posture toward the court, including in votes in the UN Security Council. One that really stands out is in the renewal of the mandate of the UN mission in Sudan, which African states had sought to tie to a deferral of the prosecution of Omar al-Bashir. And some of our strong allies, the UK and France, were willing to support this. And the US actually came down with a decision that we would veto this if there was a deferral of the Bashir investigation. And I was dispatched to London and Paris to convey this message. The Brits and the French agreed to then back off of that. So really a significant sea change from what had been going on in the first term of the Bush administration. But all of this was done in a pretty low-key fashion, really under the radar screen. And it was only with the Obama administration, when it came in 2009, where this really was adopted as a policy approach. And this cooperation became much more visible and public. So and that's maybe a segue to Jane to talk a little more about what happened during the Obama administration. But I guess just to reference back one other point that Kristen had highlighted, and that was the Dodd amendment to Aspa. And I think enough time has passed, probably the statute of limitations has expired. So hopefully I'm not opening myself up to criminal prosecution. But our view was that the Dodd amendment really gave us carte blanche to cooperate with the ICC. It is written in such a way that anybody that was determined or who had been identified as being in the US interest to support their prosecutions for war crimes, crimes against humanity, and genocide allowed us to sidestep the restrictions in Aspa. And so this was the opening for us to do this type of engagement that we did. I know under the Obama administration that they took more formal steps with presidential waivers. None of that was done in the Bush administration. But again, as I said, I think it laid the groundwork for these much more substantial changes that took place under President Obama. And I'll stop there.
Great. Dr. Stromsa, do you want to pick it up?
Yes, and I just want to thank the ABA for hosting this and echo my colleagues and friends, David and Clint, for all the important work you've done over the years on this vital issue. So the Obama administration, in which I had the honor to serve, as Clint mentioned, built upon some of the important work done at the very end of the Bush administration, but in a more public and overt way, adopting a policy of constructively and pragmatically engaging with the ICC on a case-by-case basis, consistent with US interests and law. And of course, as I think Clint mentioned, the Dodd Amendment gave a lot of space for that work. And I think there were sort of three main reasons why the Obama administration took a more robust form of engagement. One is that the ICC had become a key part of the landscape for seeking justice and accountability for the worst international crimes, genocide, war crimes, and crimes against humanity. A growing number of countries were parties, including our major European allies, and it simply wasn't possible for the US to play a leadership role as we had historically on international justice without having a more constructive relationship with the ICC. And also, thanks to David's good work in negotiating, the ICC recognizes the primacy of national accountability and the principle of complementarity built into the Rome Statute, making the court a court of last resort, is very consistent with longstanding US support for strengthening domestic processes for holding people to account. So we had this new institution that was up and running, that was playing a major role in the landscape of international justice. That was one reason. Secondly, I think the Obama administration understood that the court could advance important US interests in pursuing justice in specific situations. There were many country situations where the US had a longstanding concern. Darfur is one, but in many other places, DRC, Uganda, where we saw the court as having an important role to play. And we wanted to be supportive of that in fighting impunity for the worst international crimes, in helping where possible to catalyze domestic accountability, and contributing to prevention. And just some concrete examples of what the Obama administration did in support of the court. It expressed support for each of the cases and convictions before the court. It expanded the statutory war crimes rewards program, which offers up to $5 million for information leading to the arrest, transfer, or conviction of designated foreign nationals. And it designated, for example, 3 LRA commanders under this program. It assisted in turning over major ICC indictees, Congolese warlord Bosco Ntaganda for atrocities in the DRC, Lord's Resistance Army Commander Dominic Ongwen, and also it supported complementary accountability processes, both national and other hybrid courts like the ECCC that David's been so involved with, and regional efforts such as the AU Senegal Court to prosecute Habre, and domestic action in places like in DRC and many other places. So it saw its contributions to the ICC as both tangible contributions that could help the ICC's work, but also support US interests more broadly in advancing justice in a number of situations. And in fact, I recall one person at the ICC saying that as a non-party state, the US was at points during the Obama administration doing more to assist the court than many party states were. And I think some of the examples I gave illustrate that. And a third reason, I think, why the Obama administration believed that engaging more directly with the ICC was important was that it was helpful to safeguard US interests and concerns. And that by engaging with the court, by appearing at the ASP, by expressing our views on some issues that we had concerns about, by engaging in the negotiations, at least belatedly, on the crime of aggression and on the jurisdictional regime, that the US could advance and protect interests that it had at stake in how the ICC evolved. So I think for those reasons, the administration had a very proactive and I think ultimately constructive relationship with the court.
That's wonderful. Thank you. I think that gives us a great kind of historical overview of not only the ups and downs, but how these restrictions have limited or not limited US engagement when it chose to. I'd like to turn to the situation in Ukraine, which, as we noted in the introduction, has kind of brought this conversation to the forefront with more immediacy, even though reporting suggests the US might have already been kind of reconsidering its ICC policy. Ambassador Williamson, I think I'll start with you. What's the ICC's role in Ukraine? If you can briefly summarize maybe the scope of that investigation. And then since you've been working on that issue quite closely, what kind of support is being applied? And then I think as a follow-up to that, kind of to all of our panelists, I wonder how you think the situation in Ukraine has progressed this conversation about US engagement with the ICC. And how the legal limits we described might impact it in this particular situation, if at all. So Ambassador Williamson, we'll go to you first.
Thanks, Kristen. I think the key word here, and it's one that Jane mentioned, is complementarity. And the US approach on Ukraine very much embraces this concept of complementarity with the ICC and with domestic prosecutions by Ukrainian national authorities. So the work that I'm doing, I'm heading up a joint US, EU, UK initiative, a project to support the Prosecutor General of Ukraine and the investigative agencies there as they undertake investigations and prosecutions of crimes on their own territory. And what's somewhat unique about Ukraine, I mean, particularly when you contrast it with most of the situations in which I've worked over the last 30 years and I'm familiar with, this is very different from what we've seen in places like Syria or Myanmar or even Sri Lanka, where the national authorities were hostile toward any sort of accountability process because they themselves were complicit in crimes. Instead, Ukraine, it's a democratically elected government, which has justice and law enforcement authorities that have a mandate to investigate and prosecute crimes on their own territory. And so the United States, our European allies, the UK, all want to support this. And this is the way the ICC is supposed to work. If domestic authorities are in a position and are motivated to investigate and prosecute crimes, then that is the path that we all want to see taken. The ICC is really a court of last resort. In a situation like Ukraine, Ukraine is not a state party to the ICC. Ukraine signed the Rome Treaty, but they have not yet ratified it. But they have issued an invitation to the ICC to exercise jurisdiction over crimes that have been committed on Ukraine's territory in the ongoing conflict with Russia, going all the way back to 2014. So with the advent of this current Russian invasion in February, the ICC announced they were undertaking investigations. They have certainly taken steps to move forward with those investigations. I've met with their officials on the ground in Poland, have had other conversations with them. And I think they have very strong intentions to follow this through. But everyone recognizes that there are limitations to what the ICC can do. It's a global court, obviously. Right now, they're engaged, I think, in 16 other situations around the world. Generally, they have not issued more than 5 or 6 indictments against perpetrators in any given situation. So even if they double that number in Ukraine, you're potentially talking about 10 or 12 people. Maybe it gets a little higher than that. But there's still going to be a tremendous number of perpetrators who are going to fall below the threshold level of ICC prosecutions. And so this is what we're trying to do by supporting the national authorities. But the idea also is that these investigations that are going from ground level up within Ukraine, developing the crime-based evidence, developing the linkage evidence that goes up the chain of command, can then also feed into the work that the ICC is doing. So the prosecutor general in Ukraine, the US, and our allies are all very supportive of this concept and making sure that both parts of this equation work well. From a personal perspective, I think it's probably better if the ICC is able to bring indictments against the most senior political and military officials in Russia that might bear responsibility for crimes here, and that others would fall to the Ukrainians. But how this actually plays out in the end, I think we'll have to see. But I guess I would just sum this up by saying that it is, I think, a very cooperative relationship between the Ukrainian authorities, the ICC, and between those who are supportive of both institutions, and that certainly includes the United States.
That's great. And I'll open it up to the other panelists. Do you have thoughts on how the situation in Ukraine in particular has progressed the conversation about US support for the ICC, from either perspective, including in the United States itself? Or do you have specific suggestions for support or cooperation that could be provided with the Ukraine situation in mind? Ambassador Sheffer, you want to start?
Yeah, Jane, may I go first?
Yes, of course.
Okay. Yeah, I just want to point out 2 things. First, kudos to Clint. I mean, this guy is our champion on the ground right now for many, many weeks and many weeks to come. And he is actually, I think, I haven't confirmed this personally with him, but he's probably responsible for the best coordination that to date on these multiple investigations that are on track, and for forging the US EU joint investigative effort. And I just heard we had a third party join your little your group, Clint. I can't remember which is the third one. But I just want to say that 2 things happened as a consequence of Ukraine. One, Senate Resolution 546 was adopted fairly early in the conflict, a sense of Senate resolution that said a lot of things about Ukraine and US support for Ukrainian interests, but also had some excellent language that was quite supportive, sympathetic to the ICC. There was no negative ICC language in it. It was really supporting the concept of ICC investigation of the Russian invasion and subsequent other crimes against Ukraine and its people. That was pretty much a watershed event, because so many conservative Republican senators joined resolution 546. I think at the end it was adopted unanimously. Is that right, Kristen, on the floor?
I believe so, yeah.
Yeah, and it had a lot of, Republican co-sponsors of quite conservative bent. So that was very, very constructive. But then the Ukraine situation finally catapulted a bill that the American Bar Association has been very supportive of moving forward in drafting and getting to the floor of the Senate. And that is the Crimes Against Humanity bill that Senator Durbin has been seeking adoption of since 2009. And it kind of needed an event like this to bring it to the full sort of cutting edge moment in the US Senate. And I think we're almost there. I think in soon there will be a hearing before the Senate Judiciary Committee on the bill. And what it will do is fill the gap in US federal law on crimes against humanity, which doesn't exist right now in US federal law. It does in many criminal codes of other countries, particularly states parties to the Rome Statute. It just doesn't, it's not there yet in the US code. It also will strengthen the war crimes accountability factor in that alien perpetrators of war crimes, even if there's no US victim, will be subject to indictment and prosecution if they reach American soil. And that's very, very important, because what we don't want is the United States as a sanctuary for either alien war criminals or alien perpetrators of crimes against humanity. That's absurd. It just contradicts everything that America is about. So that's the Ukraine stimulated those two very important events in Washington, and I hope we'll see both of them. Well, 546 is history now, and now we need to make sure that the bill, which is now called the War Crimes Accountability Act, because the war crimes provision is first, since we had war crimes first in Ukraine, and then the crimes against humanity is the second component of the bill. And there are some other aspects to the bill that are very important on the Torture Victim Protection Act, et cetera. So that'll be good. And the American Bar Association has had a working group on crimes against humanity since 2015. I've had the honor of leading it. And so the ABA has been an enormous asset and help. And Kristen, you in particular at this time, and your predecessor, Kip Hale, in bringing this forward. And Michael Greco has also been on the front line supporting our efforts. So once again, the ABA has your back. That's my motto.
Dr. Stromsa,
Yes, just to, I want to commend both my colleagues. Clint, I think the work you're doing is just amazing and so vital, and we're so lucky to have you on the front line doing this work. And David, you've been tireless in trying to get domestic law on crimes against humanity and expanding the War Crimes Act. So I think these are vital initiatives, and there is, I think you're right, a galvanizing factor here with the situation in Ukraine. And I just wanted to mention a couple other aspects of that. I think the horrific nature of the atrocities, the scope, the devastation, the extreme nature, and the fact that there's clearly no possibility of accountability in Russia. I mean, Putin is denying that these things are even happening, has really shown the vital need for a sort of all hands on deck, all tools on deck approach for accountability. And the ICC is clearly part of building a web of accountability in response to these horrific atrocities. It has, as Clint notes, it has some unique aspects. It can go after high-level people. It doesn't have the problem of dealing with head of state immunity in domestic courts. So there are things that the ICC can do that are very essential in building this web of accountability. I think another couple factors to mention is Ukraine's strong support for working together in innovative ways with the ICC, the European allies and European Union support. And then I think it's also important to acknowledge that the ICC prosecutor has shown some real flexibility and nimbleness in addressing the situation by joining a joint investigative team with Ukraine, Poland, Lithuania, by focusing on the ICC as a sort of hub for information of two-way sharing. So it's not just at the apex, as he said, but it's a kind of a hub that interacts in, I think, important innovative ways with domestic authorities. And so I think there's a new sort of sense of innovation that this situation is bringing about. I also think that we have amazing leadership in the U.S. At the Office of Global Criminal Justice, and Beth Van Schack is a just incredible expert on these issues, has worked on these matters tirelessly for so many years. And I think Kristen was absolutely right to highlight the important statement that Ambassador Van Schack made at the UN, where she said the U.S. is supporting a range of international investigations into atrocities in Ukraine, including the work of the ICC, that it welcomes the opening of the investigation. I think the challenge is going to be to translate that important statement and others by the administration into robust and regularized assistance to the ICC with regard to Ukraine. And I think perhaps developing an MOU that could provide for more regularized assistance would be helpful in this regard. And I do think there's plenty of room through the Dodd Amendment, as it's been interpreted by the OLC, to provide, to allow for US sharing of intelligence, law enforcement information, diplomatic reporting, and so forth for particular investigations or prosecutions of foreign nationals accused of genocide, war crimes, and crimes against humanity, and also training and detailing of personnel to assist with particular cases. That provides a lot of room. Maybe there could be more room. Maybe there should be some tweaking of the legislative framework, but at least it provides quite a bit of room. And I would say, highlight maybe 4 areas where I think the US could be especially helpful in assisting the ICC in its work in Ukraine. First, it can share evidence of crimes, including especially linkage evidence, linking those crimes to specific responsible individuals. And there's been an expression of congressional support for gathering evidence and making sure that it is made available to investigators and courts with jurisdiction, which would include the ICC and also national tribunals. Second, I think the US could be very helpful in providing assistance to victims of atrocities in Ukraine, and also witness protection, which are often interrelated. The victims and survivors of these horrific crimes deserve our support. And one way to do this, I think, is through the ICC's Trust Fund for Victims, which is a separate entity from the ICC. It has a separate board of directors, and it has 2 key functions, one of which is to address reparations orders in ICC cases, but it also has a separate assistance mandate, which allows it to fund and support assistance programs in victimized communities in ICC situation countries, independent of any court or prosecutorial activity. And it relies on voluntary contributions. And the US has, I think, should give assistance to the Trust Fund for Victims. Some of the partners that have worked on assistance programs in different countries in Africa, for example, have been US organizations. So there have been already US participation, but there could be, I think, direct funding. And this could be done not only through funding directly to the Trust Fund for Victims, but also, as Kristen noted, the language in the current Consolidated Appropriations Act, Section 7049B, provides that funds may be made available for assistance to victims, protection of witnesses, and for other categories of assistance. I think victim support is also, and witness support and protection is also vital. And that's another area where I think the US could provide assistance. And a third area is, in the longer term, the War Crimes Rewards Program. The US could, if the ICC were to issue arrest warrants for particular perpetrators, could issue rewards, as it's done in the past for ICC indictees. That could be helpful. And I wanted to mention a 4th area, which in a way goes to the broader array of institutions working in this area. The US could provide direct assistance to the Commission of Inquiry set up by the UN Human Rights Council, which has a mandate to gather information, but also to cooperate with courts, which could include both the national courts that the national proceedings that Clint is assisting with, but also potentially the ICC. And there are a number of ways in which the US could very tangibly assist the work of the COI. I know that the ICC prosecutor has expressed concern about earmarking. He sort of said, I want a lot of assistance on personnel, resources, evidence, and so forth, but has expressed concern about earmarking. And there, of course, are many other situations in which the ICC is involved that really need support and assistance. But I think the 4 areas of assistance I mentioned would not run afoul of that concern. I mean, evidentiary assistance obviously is inevitably situation and case specific. Donating to the Trust Fund for Victims, many states that have donated have earmarked their funds for particular situations, and the US could do so for Ukraine, but more broadly for other situations as well. And the War Crimes Rewards Program obviously is targeted on particular individuals from particular cases, and assisting the COI, I think, assisting a COI that's set up specifically for a particular situation would not run afoul of this general idea. But I'm sure there are other great ways that the US could be helpful, and I'm sure my colleagues have some thoughts about that as well.
Yeah, I do. And thank you so much for those kind of specific suggestions. Do the other panelists have anything they want to add on that point, that in terms of, we've talked about how Ukraine has galvanized domestic action on strengthening our own atrocity accountability framework, on kind of domestic relationships of other states like Ukraine with the court. And then Dr. Stromsa has just mentioned some specific ways that the US could support in Ukraine, but also that might or should apply more broadly to other situations. Do others have any kind of suggestions on the particulars and how that's worked in the past, or how it could be applied in Ukraine or to other situations? Ambassador Sheffer?
Kristen, yeah, I will stand corrected if Clint or Jane want to correct me on this, but my understanding of the 2010 OLC memo is that if it's case specific, we would be able to second US personnel for that particular case. And I think Ukraine is interesting in that there could very well be some very high leadership issues or targets of the ICC in its investigations. Clint is absolutely right. We may end up with only 5 to 10 ultimate indicted suspects on the Ukraine situation before the ICC. I think that'll be an interesting discussion, at the sit room table in the White House, as to whether or not we're poking the bear too much by sending some American prosecutors to assist the ICC on a case perhaps against Vladimir Putin or the defense secretary or defense minister or some of the generals. But that, I think, is a possibility. But recall, we can also second if we identify a specific target that the ICC is working on in any of the other situations around the world. I would just expand that point by saying we can, I think, Jane, actually, you said this in part in reference to the UN Commissions of Inquiry. If the United States can be kind of the anchor of support for so many other war crimes tribunals that are operating and the UN commissions, that takes some of the heat off other countries who can then provide their resources to the ICC for Ukraine if they so choose. We can do some burden sharing here. And that can be very well recognized both by the ICC and by those governments.
That's great. Ambassador Williamson, do you have anything to add on that point? Or?
No, I don't think I would say much. I just, the point that David made about, the United States perhaps being a little bit timid about being too out in front on these prosecutorial efforts that might end up, going against President Putin or other senior Russian officials. I think the US is very sensitive to doing all of this in a multinational fashion. That's reflected by the initiative in which I'm involved. I went out the first week after the invasion. It was a multinational team. We very much tried to make it part of a multinational effort. And ultimately, the ICC, really encapsulates that in its approach with all of the states parties. But the U.S. can be a part of this. And I think where we can offer assistance, we should. I'm not sure that it's politically possible to second people to maybe have that prominent a role in this based on still lingering disagreements in Washington about how the US should approach the ICC. And we need to be cognizant of the concerns that were raised during the ICC Afghanistan investigation, which potentially implicated US intelligence and military personnel, the Israel-Palestine investigation, and the argument that was largely raised by those who were opposed to the ICC undertaking these cases is that the ICC should not exercise jurisdiction over citizens of non-states parties. So it's a bit inconsistent then for the US to argue that jurisdiction should be exercised over citizens of Russia, which clearly is not a state party to the ICC. I'm hopeful that this argument has been overcome within the policy debates that are ongoing, but it's still out there. And so I think, as we always have been in these discussions, we need to be cognizant of the fact that there still is not a unanimity of views supportive of the ICC within the US government. And some of those that have concerns about the ICC vis-a-vis US targeted investigations are still going to continue to be very cautious in the approach here. But that said, I think we should go as far as we can. I think the administration is doing all that it can to support the ICC's efforts. We're certainly working hand in hand with the Ukrainian authorities that are very interested in advancing the ICC investigation. If we can build on these things, that's great. But I just think we need to be realistic that there probably are some political limitations there.
And if I could just add, Clint, it seems like the joint investigative team, which brings together national authorities and the ICC, is a way of sort of addressing some of these concerns because it has the national component as well. And there seems to be more fluidity in sharing evidence and working together to gather evidence that might be a way of addressing some of the concerns. I also think, and there's been reporting that there's Pentagon resistance to sort of moving off of the US position of caution about supporting ICC investigations of non-state parties. But I think there's some good reasons to move beyond that or to limit its impact. For one thing, clearly in this case, we have an enormously strong interest in advancing accountability for the egregious crimes being committed by Russia. And we're working together with NATO and EU partners to give all forms of support to Ukraine, including justice and accountability. So it's, I think, fully consistent in this case to move ahead in those ways. And secondly, as I think the Obama administration discovered, engagement with the court is actually a more effective way to have US concerns now or in the future addressed than not engaging. So I think that's another argument. And then a third argument is that I think there are principled lines to draw here. I mean, as Senator Graham and others have said, this is a situation that is what the ICC was designed for, because Russia may be a non-party, but it has no interest in accountability. It doesn't have a functional system for accountability. There's complete domestic impunity. And it seems to me in situations where there's no functioning domestic justice system, no prospect of accountability, one can say, certainly in those situations, we ought to be more forward-leaning. And if that's the principle, if that's a line that I think can be supported and justified, that would mean we should be more forward-leaning with regard to the situation in Myanmar, where the U.S. has said Myanmar is committing genocide against the Rohingya. We should be out there doing what we can to be supportive of accountability there. The situation in Georgia, where the ICC has issued arrest warrants for Russians involved in atrocities there. So it seems to me there are ways to kind of move ahead and along the lines that I've suggested, even in light of the concerns that Clint, you mentioned.
That's great. That segues to my my last question. I'll just say for our participants, I would invite you to enter any questions you have into the Q&A box, which we'll get to in just a minute, and we'll have about 15 or 20 minutes for those. So please feel free to enter those now. And then I just have kind of one last question, which is certainly a part of the conversation we've already brought up, but I'd like to drill down on a little more. So as we mentioned, there's been reporting, at least, that the US is kind of reconsidering its broader ICC policy, and that process started before Ukraine. And so if you have any kind of lingering thoughts, including ones you haven't already mentioned, on how the legal framework or limits for cooperation should impact a more general US policy towards the ICC, why is a policy important, or if you have any thoughts on how kind of ICC and support for international justice and accountability interact with other US interests. Atrocity prevention comes to mind, national security, it's been mentioned in past strategies, but not consistently. If anyone has thoughts on kind of the broader picture.
Well, I think, Kristen, you sort of took the words from me very constructively at the end of your comment there. I just wanted to say that I think we're beginning to recognize, and this reflects so much of what Jane and Clint were saying, that there is a true alignment of interests between the United States and the ICC's fairly objective construct, which is governed by the Rome Statute to advance values relating to international criminal justice, to international affairs that are impacted by these types of crimes. As a negotiator, that is exactly what we were trying to accomplish in the 1990s, is an alignment of those values. And we worked very, very hard at it. And so I think the moment has arrived where that alignment is pretty much as stark as it has ever been in the last 30 years. And I would emphasize that in terms of how we could advance with a more constructive relationship with the ICC.
Yeah, I'd just like to, I'm sorry, Clint, you go first.
No, that's okay. Go ahead, please, Jane.
I just want to second what David said. I think the Ukraine situation is being an important catalyst in building toward a more constructive US ICC relationship, precisely because of those common interests that David mentioned. And of course, those common interests include strengthening domestic accountability, and when it's possible, because the ICC is a court of last resort. I really see a kind of common law evolution here in the US ICC relationship, that we can build a meaningful relationship rooted in a common commitment to accountability for the worst international crimes. And there are many points of commonality. There are situations that the UN Security Council referred to the ICC, Libya, Darfur, where the US should be supporting those robustly. The prosecutor has said he's going to prioritize those. There are many other situations where the US has long had a concern and a commitment to accountability across the world. Those are areas of common interest. Atrocity prevention. The Obama administration, thanks to the leadership of Samantha Power, put a huge emphasis on building interagency processes and tools to try to prevent atrocities before they happen. And Lord knows we need to do a whole lot more about that. And there are ways in which the US can work compatibly and synergistically with the ICC in a number of situations that will advance prevention of atrocities, including through investigations and prosecutions in various courts, through documentation of human rights abuses that are often the precursors of atrocities, through targeted sanctions on violators, through education about the principles of IHL. I mean, there's a whole host of ways in which our work on atrocity prevention and accountability is compatible with the ICC. And I think there are a whole host of areas where we can work together and or at least compatibly to advance those common interests.
Yeah, just a couple of words. I agree with everything that Jane and David said. I mean, historically, the US approach to the ICC has tended to be on a case-by-case basis, and you know, has fluctuated wildly over the last 20 years. But some of these individual cases have then brought about more systemic policy changes. Certainly, President George W. Bush's concern about the situation in Darfur led to a changing perspective on the ICC. And I think a recognition by the end of the Bush administration that even if there were some policy differences between the US and the court, there needed to be this understanding that in some circumstances, the ICC is going to be the best or perhaps even the only policy alternative open to the US for pursuing accountability, stabilization, long-term reconciliation, and therefore it needs to be part of any toolkit that the US has for dealing with contingencies such as this. So, as I said, even one situation, one case can give rise to broader policy changes. And that is what happened with Darfur. I'm hopeful that that would be the same with Ukraine. But the other point I made, where policy has fluctuated, this is not an ideal way to operate as a government. I mean, we really have been on a roller coaster of a relationship with the ICC that, you know, the great work that David did during the Rome negotiations, and then ultimately getting the US signature on the treaty, this huge drop in the first term of the Bush administration, you know, a reversal of that in the second term of the Bush administration, a continued upward trajectory throughout the Obama administration, then another crash under Trump, and sort of a slow upward trajectory that's occurred under the Biden administration. So it would be great to be able to incorporate a more sound policy approach into US foreign policy and try to allow for a much more consistent relationship that's not dependent on the whims of whoever's in the White House. That's probably difficult to achieve, but it's something that we should strive for. And some of the things that are being done in terms of changes in domestic US legislation, that's a step in the right direction. But the more that we can get the US relationship with the ICC on a regular footing, the kind that we have with other international organizations, with multilateral bodies, and with bilateral relationships with states, I think would be a positive thing.
Can I just jump in to note as an add-on to Clint's point that there is a fairly substantial report that was issued by the American Society of International Law late last year, in which our current Ambassador at Large for Global Criminal Justice, Beth Van Schaak, was actually a co-author of. And so if anyone is interested in sort of expanding what Clint was saying, like how do you build a consistent relationship with the ICC, I think that was one of the aims of that report, was to kind of set that down. What would be a consistent, solid relationship short of actually becoming a state party? So I would recommend that to everyone. Jane, I can't remember whether you were part of that group or not. I think you were, weren't you?
Yeah, I was one of the advisors. I think
Yeah, exactly. You were part of the advisory group. So,
It's an
you
excellent
know,
and comprehensive report. I'm glad you mentioned
yeah,
it.
yeah.
Yeah, definitely recommend that one. It's got tons of information, just on the history and the ways the US has engaged, including some specifics in addition to the kind of strategic point that Ambassador Sheffer mentioned. I've got a few questions. So I'll start with a comment that one of our attendees noted, and then maybe I'll put 2 or 3 questions out there just since we only have 10 minutes left. The first comment, which as a legal organization I wanted to highlight, is that reminding us that the ICC also has a visiting professional program, which this person suggests is an avenue for US legal professionals and students, along with other professions like psychology, counselors, interpreters, to contribute constructively individually, even absent a consistent government policy. So, they're suggesting perhaps if more individuals were sensitized to the ICC through programs like this, we could see some incremental attitude change. So, that is a program, certainly if you're listening to this and are interested, that you should look into. And, I think as the organization representing the legal profession, would encourage more US legal professionals to engage with this and other tribunals in order to kind of build a long-term understanding within the profession. So then I'll go to a few questions. This first one, I think we've kind of addressed maybe in this last question, but it's basically a complementarity issue, noting that the ICC is needed, but it was created to investigate, prosecute cases where states can't do so. And I'll just note the language is, if it's not just they can't do so, but also if they're unwilling. So unwillingness is a key part of that equation. But the question is, if so, then why should the US concede to its jurisdiction, even if we do support its existence and mission? So that's one, if anyone wants to take that, but I'll add a few more. Then there's 2 similar questions, so I'm going to combine them. By supporting the Ukraine situation, but potentially not others, does this raise concerns of double standards or selectivity? And then there's a second part, which is also, which I want to address to this group, also what would you recommend in terms of a strategy to seize this moment of a more positive view of the ICC in the United States to influence the underlying US objection? So I'll let you pick which one you want, or if any, but there's 3 questions, again, to summarize, kind of why should the US concede its jurisdiction, even if the US supports the ICC's, overall mission and existence, including complementarity issues? And then does support for Ukraine raise questions of double standards based on kind of past US policy? And then also, if you have any suggestions in terms of strategy in seizing momentum for a more positive kind of underlying, ICC policy. So I'll let you pick any ones you want.
Maybe I'll start. I would just say this about the question on double standards. International justice is far from universal at this point. It's still far from being equitably applied. This is ultimately what we're striving for. And when I first started at the Yugoslavia Tribunal in 1994, when it was brand new, I was in the very first group of people in the office of the prosecutor. People gave it very little chance of succeeding or of accomplishing much. When you look at what has happened in the 30 years since then, international justice has expanded significantly. We've seen heads of state that we never thought would be in the dock ended up being prosecuted. So the advances that international justice has made are substantial in what is really the blink of an eye in terms of kind of the global history of law. And certainly David, who is at the foundations of this, deserves a tremendous amount of credit. But we have come such a long way in such a short period of time. But that said, we have to recognize we still have a long way to go. So it's not universal. The US has not been 100% consistent in its approach to international justice, and has certainly been very mindful of protecting its own national interests and what are perceived to be the national interests of close allies. Hopefully we'll get beyond that at a certain point, but I think we just need to keep that in perspective. The other point about sort of the role of the ICC when you have domestic prosecutions. I think the question was asked in the context of the US, and I think you're right. I mean, the US does have a robust civilian and military justice system. We have a free press. We have a legislature that investigates and opens up information on things. So we do have a very solid criminal justice structure and framework that's in place that hopefully would not require the use of the ICC. Well, let me shift that a little bit to Ukraine. Ukraine also has very strong domestic capabilities. But I think in the context of what's going on right now, their ability to ever secure the arrests of senior Russian officials is pretty doubtful. It's also going to be hard for the ICC to get their hands on senior Russian military and political officials unless you have a change to a more rule of law oriented government in Russia. But the fact is, if you have ICC indictments or arrest warrants issued for these senior officials, in many ways, these are going to be much more significant than if these are coming from Ukrainian national authorities. It is going to reinforce the pariah status of these individuals. It's going to make it much more difficult for them to travel and to conduct business on the world stage in the way that they have been used to. So even in a place like Ukraine, where I think you do have very capable national mechanisms for advancing accountability, the ICC can still play a vital role and should play a role. And again, we should be supportive of that.
Thanks so much. Does anyone want to add to those or take one of the other questions, including about how to kind of seize the moment for those who are interested in advancing a more supportive U.S. policy here?
I'd like to echo and support everything Clint just said. I think the current moment shows the value of mutually reinforcing accountability, of looking at different mechanisms and how they can work together in a constructive way. They have different capabilities, different strengths and weaknesses, but somehow if we put them together and take the best of what each of them can do and offer, it can be, I think, quite significant. In terms of seizing the moment, I think that this moment and seeing what's going on in Ukraine in terms of the absolutely egregious, shocking, and devastating Russian atrocities is a moment that grabs and galvanizes attention. And I think getting congressional support. I think David mentioned earlier on the importance of the congressional acknowledgement of the role of the ICC, the importance of domestic legislation. I think this is all important. I also think it's important for military leaders to speak up. And I want to mention General Wes Clark in July of 2020 wrote a very powerful piece in Foreign Policy where he talked about how the US shouldn't be so defensive, that we should be more transparent, more confident in our ability to address our own problems, should engage and support the ICC. And I think getting senior military officials who've had the kind of experience he's had in the Balkans and elsewhere speaking up is also very, very valuable and important.
I subscribe to all of that, and just note that there are small steps and there are large steps. One small step occurred a couple of weeks ago when ICC prosecutor Karim Khan paid a visit publicly, although he had private meetings as well, but he paid a public visit to Washington, D.C. and with officials he interacted with people in Washington, let's put it that way. And that's a very important step for Washington to be welcoming visits of that character from the court.
That's great. I think we're close to time, so I'll just ask if any of our panelists or if Michael Greco has any, kind of lingering thoughts or last words they want to say.
Well, Kristen, thank you. I think this has been an outstanding program. The comments made by Ambassador Sheffer, Ambassador Williamson, Dr. Stromsa make a lot of sense. Setting at the very beginning how the relationship between the U.S. and the Icc began in the Clinton administration, which ended with support for the court, and then the Bush administration, Obama, and so forth. Very informative, very educational. And I'm hoping that this video will be shared and viewed by a lot of people, and including our government leaders. So I want to thank each of the three of the panelists for their time and for their thoughts, and I thank you very much. And I want to commend Kristen Smith, who put this program together with the questions, with everything, and then moderating it. I'm very happy that we've had the program, and I congratulate and thank everyone who's made it happen. So thank you very much.
Thank you. And I'll just add my thanks to both Michael and our panelists for joining. We know you're all really busy and continue to work on these issues, as you said today. So we're very grateful for your time and your expertise. And I think you've given everybody a lot to think about how to push this issue forward. All right, and with that, we'll wrap it up. We hope to see you at more criminal justice section and Center for Human Rights events, including on the ICC in the future. So thanks everyone for joining. Bye.
Thank you. Goodbye.